There are moments in public life that strip everything away. The title, the office, the years of carefully maintained image. Moments where a person's true character, the version they've spent years dressing up in language and ceremony, finally stands exposed in a room where neither rank nor reputation can protect them. I've spent years studying how power behaves when it believes no one is watching, and more importantly, how it behaves when it believes it's above the consequence of being watched. I've looked at cases from county governments to federal offices, from small municipalities to major urban centers. And across all of that, one pattern repeats with unsettling consistency. The people most likely to break the rules are almost never the people at the bottom. They are the people who have been told, long enough and by enough admiring voices, that the rules were never really meant for them. What happened in that courtroom was not a surprise to the people who had worked around Marcus Holden for years. It was the moment they had quietly anticipated, feared, hoped for, and then finally witnessed for a very long time. What was surprising was how quickly it ended. Not the investigation, not the legal process, but Holden himself. 2 minutes. That's how long it took. But to understand what those 2 minutes meant, you have to understand the man who walked into that room believing he would walk out unchanged. Marcus Holden had been mayor of Caldwell Falls for 11 years. A mid-sized city, roughly 200,000 people, built around a mix of light industry, a regional hospital system, and a university that brought in enough economic activity to keep things moving. It wasn't a glamorous city. It wasn't a national story. It was the kind of place where a mayor could build a career and a legacy and a reputation that extended just far enough beyond the city limits to feel significant. And Holden had done exactly that. He was elected at 41 on a platform that combined moderate fiscal policy with a particular kind of folksy directness that played well in local press. He shook hands firmly. He remembered names. He showed up to ribbon cuttings and memorial services and high school sporting events with the regularity of a man who had been told and had come to believe that presence was the same as leadership. By his third term, something had changed. The ease of re-election had done something to him that unchallenged authority tends to do. He had stopped distinguishing between what he was entitled to as a person and what he was permitted to do as an official. The line between Marcus Holden the individual and the office of the mayor had, in his own mind, dissolved entirely. His staff noticed it first, not in dramatic episodes, but in the accumulation of small moments. The way he spoke to department heads, not as colleagues, but as subordinates who should be grateful for the clarity of his direction. The way he handled budget discussions, cutting off questions with a wave that communicated that analysis was for people who didn't already know the answer. The way he treated the city's legal counsel, a position occupied by a quietly exceptional attorney named Renata Voss, as if her advice was an optional formality rather than a professional boundary. Renata Voss had been the city's legal counsel for 7 years. She was meticulous, even-keeled, and possessed of the particular patience that comes from having spent a career advising people in power who often mistook authority for infallibility. She had worked for 2 mayors before Holden. She had navigated difficult conversations, protected the city from costly missteps, and managed the gap between what elected officials wanted to do and what the law permitted them to do, without fanfare, without credit, and with consistent professionalism. By year 8 of Holden's tenure, she had begun keeping records, not because she was planning anything, but because the gap between what she was advising and what was being decided had grown wide enough to concern her in ways she couldn't responsibly ignore. The case that brought everything to a head began not with a dramatic action, but with a contract. A development group, a private firm with connections to several of Holden's longtime political associates, had submitted a proposal for a mixed-use development on a parcel of city-owned land near the university. The proposal had gone through the normal channels. The City Planning Commission had reviewed it, raised concerns about density requirements and community impact, and recommended modifications. The City Council had voted narrowly to accept the Commission's revised terms. Holden had signed off on the Council's decision publicly. Then, through a series of internal memos and administrative directives that bypassed both the Council and the Planning Commission, he had authorized a version of the contract that reflected the developer's original proposal. Not the revised version, not the terms the Council had approved. The original. The difference was not trivial. It involved several millions of dollars in city-managed infrastructure contribution, a significant relaxation of density limits, and the removal of a community benefit clause that would have required affordable housing allocation within the development. When the discrepancy was discovered by a council member who happened to request the final executed contract for an unrelated review, the reaction was swift. A formal complaint was filed, an independent investigation was opened, and within that investigation, something emerged that even Holden's critics hadn't fully anticipated. He had known. Not only had he authorized the revised contract, but internal communications, emails and memos retrieved from the city's administrative servers, showed that he had been informed explicitly by Renata Voss that bypassing the council's approved terms in this manner was not within his administrative authority. Her written advice, dated 3 weeks before the contract was executed, was precise and unambiguous. She had outlined the procedural requirements, identified the specific legal parameters of his executive authority, and stated clearly that proceeding without council approval on the modified terms would constitute an unauthorized exercise of mayoral power. He had proceeded anyway. The investigation took 6 months. During that time, Holden continued to serve. He continued to hold press conferences. He continued to appear at events and deliver the kind of remarks that suggested everything was fine, that the investigation was a political maneuver by opponents, that the facts would vindicate him, that the city deserved a mayor who was willing to make bold decisions rather than getting tangled in procedural obstruction. He used those words, procedural obstruction, as if the City Council's vote, the Planning Commission's recommendations, and his own legal counsel's written advice were obstacles rather than the legitimate exercise of governmental process. The people who had worked alongside him for years heard those remarks and felt something shift. Not surprise. They were past surprise, but a clarification, a confirmation of something they had suspected, that Holden had not simply made a mistake. He had made a decision, and the decision was that his judgment outranked everyone else's authority. When the investigation concluded and its findings were referred to the appropriate court for remedial action, a hearing was scheduled. Holden was ordered to appear. His attorney filed 2 motions to delay, both denied. He was ordered to produce specific administrative communications. His office produced a version of the record that the court found, upon review, to be materially incomplete. A second order was issued, more specific in its requirements. That second order was the one he ignored. Not misread, not misunderstood, ignored. His attorney, at this point visibly uncomfortable with the position she was being placed in, filed a response that attempted to characterize the production as compliant. The court disagreed. The judge overseeing the matter, the Honorable Charles Abara, a former civil rights attorney who had spent 15 years on the bench, issued a show-cause order requiring Holden to appear personally and explain why he should not be held in contempt for non-compliance. Holden arrived at that hearing in a dark suit with a gold pin on his lapel. The pin bore the city's seal, a small detail, but one that people in the room noticed. He wore the city's emblem into a hearing about his violation of the city's legal process. Whatever that says about self-awareness, it says something. Judge Abara had reviewed everything: the original contract discrepancy, the investigation's findings, Voss's written legal advice, the 2 orders Holden's office had failed to fully comply with, the motions to delay, The incomplete document production. He had read it the way a careful person reads something they intend to act on. The hearing began simply enough. Holden's attorney made an opening statement that attempted to reframe the document production issue as a logistical challenge, a matter of administrative complexity rather than deliberate non-compliance. She was thorough and professional. She was also, clearly, working with material that could not be made into what she needed it to be. Then the judge addressed Holden directly. He didn't raise his voice. He didn't use charged language. He simply asked, with the clarity of someone who already knows the answer, whether Holden was aware of the court's order. Holden said yes. Whether he had understood its requirements. Holden said yes. Whether he had taken steps to comply. Holden said his office had worked in good faith to produce what was responsive. Judge Abara set down the document he was holding. He looked at Holden steadily and said that the court had reviewed the production and found it to be materially non-compliant with the order's specific requirements. He asked whether Holden had any explanation for the gap between what was ordered and what was produced. Holden paused, and then he said something that has been described by everyone who was in that room as the moment the air changed. He said that as mayor of Caldwell Falls, he had a responsibility to protect certain administrative functions of his office. He said that the court's order, as written, created a conflict with the operational requirements of the executive branch of city government. He said he had made a judgment call in the interest of the city. He called it a judgment call, in a courtroom, explaining non-compliance with a court order. He described his decision to not fully comply with a judicial directive as a judgment call. Judge Abara looked at him for a moment that several observers later described as both brief and very long. Then he spoke. He said, calmly and with complete precision, that the court did not operate on the judgment calls of elected officials. He said that a mayoral office did not possess the authority to determine which court orders it would comply with and which it would not. He said that the record before him, not the characterization of it, but the actual record, showed a pattern of behavior that included the unauthorized modification of a council-approved contract, the disregard of explicit legal advice from the city's own counsel, 2 delayed responses to court proceedings, and a materially incomplete response to a specific court order. He did not say these things with anger. He said them the way a person states facts they have verified and are prepared to act on. Then he found Marcus Holden in contempt of court. The finding came with immediate conditions. Holden was given 72 hours to produce full compliance with the original order or face escalating sanctions. Those sanctions would include, pending review of the broader findings, a formal referral to the state office responsible for municipal officer conduct, a referral that carried with it the formal authority to recommend removal from office. Holden's attorney took notes. Her expression was professional and unreadable, in the way that expressions become unreadable when someone has practiced controlling them under pressure. Holden's expression was something different. It was the expression of a person encountering a wall they had not believed was actually there. Not anger, at least not yet. Something closer to incomprehension. The look of someone who had navigated through spaces for so long by force of personality and assumed authority that the experience of a hard, immovable limit was, in that moment, genuinely disorienting. He had walked into that room as the mayor. He had spoken as the mayor. He had offered his justifications in the language of mayoral responsibility and executive judgment, and none of it had moved anything. The record was the record. The orders were the orders. His title had not changed what was true. 2 minutes. From the moment Judge Abara began speaking to the moment the contempt finding was issued. That's all it took. Not because the judge was in a hurry, but because the facts were clear, the law was clear, and there was nothing left to deliberate. In the days that followed, the contempt finding did what these things tend to do. It clarified everything. The local press, which had given Holden considerable benefit of the doubt during the investigation, now had a court-issued finding to report rather than allegations to navigate. The coverage shifted. The framing shifted. The city council, which had been divided about how forcefully to respond to the initial contract issue, found its position suddenly and significantly easier to articulate. Renata Voss, who had given her legal advice in writing, watched from a professional distance. She had not cooperated with the investigation beyond what was legally required of her. She had not made public statements. She had not offered commentary. But the memo she had written, the one dated 3 weeks before the unauthorized contract was executed, had become one of the most referenced documents in the entire proceeding. Her advice had been ignored. Its correctness had been definitively confirmed by the chain of events that followed. That's a specific kind of professional vindication that doesn't need words. The referral to the state office proceeded. Holden retained a new legal team for that phase, a larger firm with more resources for what was clearly going to become a more prolonged and consequential process. He gave an interview in the local paper in which he spoke about public service and the complexity of governance and the burden of making difficult decisions. He was measured. He was articulate. He was, in the language of people who have learned to speak carefully after speaking carelessly, recalibrated. But recalibration is not the same as accountability. And accountability, when it finally arrived, came in the form of a state board finding that recommended his removal from office on the grounds of official misconduct. The city council voted on whether to accept that recommendation. The vote was not close. Marcus Holden's tenure as mayor of Caldwell Falls ended on a Tuesday afternoon. He did not appear at a farewell ceremony. There was no formal send-off. The city seal pin, the one he had worn into that courtroom, was returned, along with the rest of the official materials of the office, as part of the administrative transition. The deputy mayor, who had served in that role for 4 years, and who had spent much of that time navigating the complications created by decisions she had not been fully included in, assumed the mayoralty pending the next election. She held a brief press statement. She thanked the city's residents. She said she understood the weight of the responsibility. She made no remarks about her predecessor. She didn't need to. The record spoke clearly enough. What this story is ultimately about goes beyond one mayor and one city. It goes beyond the specific contract, the specific court order, the specific finding of contempt. Those are the facts. But underneath the facts is something that appears again and again in these situations, with a consistency that should concern all of us. Power, when it goes unchecked and unquestioned for long enough, stops believing in its own limits. It doesn't happen all at once. It happens through accumulation, through the small moments where someone expected pushback and received deference instead, through the decisions that should have generated consequences but generated only silence, through the gradual normalization of a gap between what is permitted and what is being done. Marcus Holden did not arrive at that courtroom as a corrupt official who had always been corrupt. He arrived as someone who had been shaped, slowly and incrementally, by a political environment that had not held him accountable at any of the earlier junctures where accountability would have been appropriate. The moment he bypassed the Planning Commission's recommendations without consequence. The moment he dismissed Voss's legal advice without consequence. The moment he delayed compliance with the first court order without immediate consequence. Each of those moments sent a message, and the message was, you can do this, and remain who you are, and hold what you have. Until, finally, one moment sent a different message. Not from a political opponent, not from a journalist, not from a disgruntled employee, from a judge who had read every document, understood every detail, and was not interested in the performance of authority, only in its legitimate exercise. The people of Caldwell Falls had elected Marcus Holden. They had trusted him with the executive power of their city. They had watched him for 11 years, and the contract he modified, the order he defied, the hearing he arrived at with the city's seal on his lapel, All of those were actions taken in their name, with their resources, at their expense. That is what makes this more than a courtroom story. That is what makes it a story about what elected office actually means. It means something was given to you, not owned by you, given. And the giving comes with conditions, legal, ethical, procedural, that exist precisely because power without conditions is not office. It is occupation. Renata Voss had written those conditions down 3 weeks before the contract was executed, with clarity and specificity and the professional integrity of someone who understands that her job is to advise accurately, not palatably. She was ignored, but she was right. And in the long run, being right, carefully, documentedly, professionally right, is what survived. Not the authority of a man who believed his office exempted him from the rules he was elected to uphold, but the quiet, persistent accuracy of a memo that told him the truth before any of this began and was eventually placed in front of a judge who knew exactly what it meant. Some people believe that power protects you. That rank is a kind of armor. That title changes what is true. It doesn't. The document doesn't change. The timestamp doesn't change. The law doesn't change. And the record, the actual, complete, unspun record, was always there, waiting, the way truth waits, without impatience, without performance, entirely indifferent to the confidence of the person who tried to override it. Marcus Holden lost his badge in 2 minutes because it had already been lost long before he walked into that room. Lost at the moment he chose to treat public office as personal authority. Lost at the moment he read Renata Voss's advice and decided it didn't apply to him. Lost at the moment he signed a contract that was not what the counsel had approved and believed no one would look closely enough to notice. The 2 minutes was just the moment the rest of the world caught up to what was already true. And in a city of 200,000 people, people who went to work, paid taxes, used the infrastructure, lived in the neighborhoods affected by development decisions, that truth mattered. It mattered in the way that accountability always matters, not just as an abstraction, but as something felt and lived, and finally, after too long, resolved. Justice doesn't always arrive on time. Sometimes it's late. Sometimes it doesn't arrive at all. But when it does, when the right document is in the right hands in the right room, and when the person reading it has the clarity and the integrity to act on what it actually says, it is one of the most important things a society can witness, not for the satisfaction of a downfall, but for the confirmation of something we all need to believe is still possible, that no one, regardless of title, regardless of years in office, regardless of the certainty with which they walk into a room, no one is above the law that everyone else is expected to live within. That is what 2 minutes can mean. Not an end. A reckoning. And sometimes, a reckoning is exactly where the right story begins.